All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good afternoon, everyone, and welcome to the 4th Court of Appeals. I am Justice Lucelena Chapa. To my right is Justice Beth Watkins, and to my left is Justice Lisa Rodriguez. You may be seated. Thank you. The court has convened today to hear arguments in cause number 0422000136 CV, Barrett Firearms Manufacturing, Inc., Barrett Firearms USA, Inc., and Federal Cartridge Company versus Xavier Flores. The time for oral argument is limited to a total of 20 minutes for opening argument for all appellants, 20 minutes for appellee's argument, and 10 minutes for rebuttal. There is a timer at the podium, and you will start with your allotted time. A yellow warning light will appear to signal you at 5 minutes left for opening argument and 2 minutes left for rebuttal. And now I will call for announcements, please.
Jamie Parker and Chris Strong on behalf of Barrett Firearms defendants or appellants.
Welcome.
Danny Lawless on behalf of Appellant Federal Cartridge Company.
Welcome.
Jen Rosenblatt and Wendy Martinez on behalf of Xavier Flores.
Welcome. Gentlemen, will you be splitting your time? Both of you arguing?
Your Honor, the way we are going to approach it is that I will argue the opening for the first 20 minutes and Mr. Parker will do the minutes on rebuttal.
Okay. Thank you, gentlemen. And only Ms. Rosenblatt will argue on behalf of Mr. Flores. Thank you. Feel free to bring water to the podium and drink at the podium as you wish. And appellants, if you'd like to begin, we are ready when you are.
It's Lawless.
Lawless, okay.
L-A-L-L-I-S, but it's pronounced Lawless.
Thank you, Mr. Lawless.
Thank you. May it please the court. My name is Danny Lawless and I represent Appellant Federal Cartridge Company. Now, this case concerns the appropriate scope of Section 128.053 of the Civil Practice and Remedies Code. This section creates a threshold expert report requirement in suits against sport shooting ranges. In such lawsuits, this section requires a plaintiff to serve an expert report on each defendant against whom a claim is asserted within 90 days of filing their petition. If no expert report is served, the defendant should be dismissed. Now, today, I want to kind of focus on and emphasize 3 main points that we both Appellant Federal and Barrett touched upon in their briefings. First, the plain text of Chapter 128 mandates dismissal of the appellants in this case. Second, a comparison of this statute at issue to another statute with threshold expert reporting requirements demonstrates that Section 128.053 is intended to be read broadly and not narrowly construed, as appellees have argued. And third, the Supreme Court's recent holding in Schnoegel v. Whitlock also supports the dismissal of the appellants Federal and Barrett in this case. Now, by way of just brief background, Your Honors, because it is somewhat important to the application of the statute in this case, plaintiff was allegedly injured while he was a paying customer at a sports shooting range. He had rented a .50 caliber rifle that was manufactured by Barrett and owned by the range, and he received .50 caliber ammunition from the range. That .50 caliber ammunition had been manufactured by Federal. While under the supervision and instruction of the range safety officer, plaintiff and other members successfully fired this rifle a few times, I think 8 times. While attempting to load the 9th round, the firearm allegedly misfired. Plaintiff brought suit against the shooting range and Barrett originally. Subsequently amended the complaint to bring claims against Federal, the manufacturer of the ammunition. Within the second amended petition, which is the operative petition in this case, plaintiffs asserted causes of action for negligence, strict liability, and breach of warranty against all three of the defendants. In their factual allegations, plaintiff has alleged that the shooting range was negligent both in its supervision and instruction of the plaintiff, as well as failing to properly maintain, use, and inspect the equipment at issue, which in this case would be the rifle and the ammunition. It's undisputed, and no party has disputed, that plaintiff has never served an expert report in this case of any kind. Because of that, all three defendants moved to dismiss in the trial court. The trial court held that this is a suit against a shooting range, a sports shooting range, and found that chapter 128 is applicable. However, the trial court only dismissed the claims against the named shooting range defendants. The trial court seemed to make a distinction with the manufacturing defendants, finding that this statute does not apply to the defendants.
Mr. Lawless, because there's a permissive appeal, we're limited to trying to answer what is delineated in the court's order. We're well familiar with the facts and the pleadings that are established in the record. So if we can go to, and I know I cut you off somewhat, but if we can go to the order, we're trying to here answer whether the Barrett defendants and federal are affected or implicated defendants under the statute. And that will determine whether or not the requirement to file a timely expert report applies to them. So if we can hone in on that so that we can focus and try to get to the crux of your argument, it would be helpful.
Certainly, Your Honor. And that brings me to the first point, which is the plain text of the statute itself. Section 128.053A specifically states that it applies to a suit against a sport shooting range, and it requires the service of expert reports on each defendant whom a claim is asserted. In this case, Federal and Barrett are both defendants against whom claims are asserted. Within that same statute, the legislature defined what they meant by claim in section 128.051. And they said claim means any relief sought in a civil action. They did not limit that definition to claims against shooting ranges. So if you read section 128.053A, where it says for each defendant against whom a claim is asserted, that clearly implicates Federal and Barrett as well as the shooting range defendants.
Okay, but the statute does limit, or rather, it defines expert and expert report. And that does limit to either shooting range owner or operator of a shooting range or a property owner on which the shooting range exists.
Your Honor, yes, the definitions also include a definition of expert report. And within that definition, first, let me back up and say that the definitions need to be read in conjunction with each other and in conjunction with 128.053A.
And when you mean conjunction, you are referring to the entire chapter of 128, beginning with the title, correct?
Correct. The entire chapter beginning with the title, the limitation on suits against sports shooting range or firearm or ammunition manufacturer, trade association, or seller. Your Honor, to get to your question about the definition of expert report, in the definition of expert report within the statute specifically references the standards applicable to a shooting range and how the standards applicable to a shooting range are implicated or are causative of the happening of the incident. In this particular case, plaintiff has argued that it's fortuitous that the firearm and the ammunition just happened to be there in the range, but that's not. Ammunition are part and parcel of the business operation of the shooting range. In this case, the bullet hole. The bullet hole, as alleged in the complaint, part of their business is to rent firearms and provide ammunition to customers. So therefore, that clearly implicates the standards applicable to shooting ranges in this regard. Specifically, the allegations in the complaint are intertwined between the defendants Barrett and Federal and the shooting range.
How so? If they asserted a premises case against bullet hole and asserted a to simplify things, products liability cases against Barrett and federal.
Well, let me thank you, Your Honor, for that question. Let me respond this way with a couple things there. Section 128.053A does not differentiate between claims within a suit. It simply says a suit against a sport shooting range. And this is a suit against the sport shooting range. So I don't know if you can parse out. In this particular instance, plaintiff chose strategically to sue both the manufacturers of the ammunition and the rifle, as well as the range, in one lawsuit, alleging intertwined allegations. And we can look to the complaint within the negligence causes of action against the bullet hole defendants, the range defendants. They included the failure to properly maintain, inspect, and use the equipment that are issue, which is the ammunition and the rifle. So for example, if the rifle was not properly maintained or if it was modified, that would implicate both the potential defenses from Barrett, but also the standards applicable to a shooting range and what they're required to do when maintaining rifles or any other equipment and holding it out to the public. It's no different than the ammunition that is being offered as part of a rental with the firearm. The ammunition, there's certain requirements regarding how it's stored, to whom it's offered. And again, all those considerations implicate the standards that are applicable to a shooting range.
Okay,
And so,
but we don't have a report, do we? Here in this case, we don't have a report that was served on the parties.
correct. There was no report served.
Okay, and there's no dispute. I mean, that's a done deal. And bullet hole is no longer a named party in this case, correct?
Well, bullet hole is after the motions to dismiss and the court determined that this statute only applied to bullet hole was dismissed from this case. Yes, Your Honor.
Okay, is it your position that Barrett and federal, let me back up a little bit. Is it your position that the appellee rather, must have served an expert report on Barrett and federal?
Yes, Your Honor. In this statute, when you read this statute, it creates a threshold requirement regarding suits against sport shooting ranges.
Okay, and does the statute give any guidance as to what that report should contain?
The statute, the report against, well, let me start this way. In this case, the issues on appeal are not related to what was in a report or not in a report because the plaintiff never met that threshold requirement.
Right, and it's almost counterintuitive because if we're talking about an implicated defendant and the words implicated in a report, that's only when we have a report, right? So then help us understand how we reconcile that when there's no report and you are still trying to seek the protections or I guess benefits of 128.053B in terms of a dismissal.
Thank you, Your Honor. And yes, and again, in reading the plain language of 128.053A, it applies in a suit against the sport shooting range, and it has specific requirements about the timing of when an expert report is to be provided. That's 90 days. Or plaintiff can, and the parties can agree to a longer period of time. Neither of those things happen. Once that didn't happen, all of the defendants, so in 128.053A, it says, for each defendant against whom a claim is asserted. Barrett and federal are defendants in a suit against a sports shooting range against whom a claim has been asserted. Plaintiff's failure to provide an expert report in conformity with this section of the statute means that Barrett and federal should have also been dismissed at the trial court with the shooting range defendants. This statute creates sort of a preliminary threshold, a prerequisite to maintaining a suit against a sports shooting range, of which Barrett and federal are defendants in.
Counsel, would we be here today if Flores had not sued Bullet Hole?
If Flores had
only sued Barrett and Federal.
If Flores had only sued Barrett and Federal, and that was the only thing in the petition, then no, because that would not be a suit against the sports shooting range.
So help me understand why, looking at the definition of expert report that limits it to applicable standards of care for operation of a sports shooting range. Federal's not a sports shooting range. Barrett's not a sports shooting range. How would this expert report, what would the content have been that would have inured to your benefit?
Well, thank you, Your Honor. But again, there has been no expert report served. So our position is that they did not meet the threshold requirements.
Right. But what Shinogle tells us is that we look at defendants whose conduct is implicated in the expert report. Also in Shinogle, there wasn't an expert report. So how do we figure that out when in the absence of a report? Shinogle tells us we look to the pleadings, right?
Correct, Your Honor. Shinogle does say we do look to the pleadings and that the implicated defendant, Shinogle uses the term implicated defendants. In Shinogle, the plaintiff there tried to also construe the statute very narrowly. And the trial court there said, well, because the word employee does not appear in the statute, it does not apply to an employee.
Well, is it when we're trying to do statutory construction, don't we look at every word that the legislature used, and each word has meaning and understanding behind it? And so we're not to assume that something was left out. And that's how that's why we're here today, right? Trying to, and Justice Watkins, I know I interrupted Mr. Lawless, but if we're looking to the statute itself in terms of constructing it, I don't see how in Shinogle, I guess to say it this way, it seems as though the Supreme Court was able to find Mr. Shinogle as a matter of law, he was an implicated defendant, potentially because there was a theory as a matter of law with respect to responding at superior. So the shooting range and the officer were essentially one and the same. Here we don't have that fact scenario.
Well, thank you, Your Honor. Well, in Shinogle, there were separate causes of action against the shooting range, Alpine, and the employee. There was a separate negligence cause of action and a separate gross negligence cause of action. The respondeat superior argument related to trying to argue that the plaintiff's the actions of the employee or also the actions of the range. I don't read Shinogle to be limited to saying that only implicated defendant are employees of the range. In this case, based upon the pleadings, and as Your Honor correctly pointed out, the Shinogle decision says to focus on the pleadings in this case. And in this case, the pleadings show that the standards applicable to a shooting range, to the shooting range in this case, are directly at issue in this case when it comes to Barrett and Federal. The manner in which the ammunition was maintained and stored and utilized are key issues in this case.
But counsel, Shinogle, through operation of the doctrine of respondeat superior, we know that the employee and the employer at issue in Shinogle were essentially one and the same for legal purposes, that the actions of the employee are imputed to the actions of imputed to the employer, because the employer can only act through its people. But we don't have that here. Barrett and Federal, on one hand, are not one and the same with bullet hole. Help me reconcile that.
Well, again, Your Honor, the holding of Shinogle starts with the premise that you need to interpret the statute based upon the plain terms and definitions. Shinogle did not find the statute to be ambiguous, did not resort to anything other than a plain reading of the statute. The question that they were tasked with was whether under that factual circumstance, did it meet the definition supported by 128.053A? And they rejected the argument that there's some type of limitation on it. They held that 128.053A is to be broadly construed. You don't, just because the term employee doesn't appear in there, doesn't mean that it doesn't apply. And we're arguing the exact same thing, that looking at the plain terms of the statute, looking at 128.053A, which says in a suit against a sports shooting range, claimant shall serve on each party one or more expert reports for each defendant against whom a claim is asserted.
So let's assume if Mr. Flores's treating physicians, somehow, I believe he had some hand surgeries or maybe some grafting. Let's assume that one of the treating physicians was also a defendant. And so being that Mr. Flores here in this case didn't serve an expert report, would the treating physician also be entitled to a motion to dismiss?
Thank you for your question, Your Honor. And the first thing that I would say is that that's not the facts of this case. The treating physician is not here. We have to take the facts of the cases as they are presented. And in this case, plaintiff brought a suit against a sports shooting range and included within that suit allegations that were intertwined with Barrett and Federal, the manufacturers of the products that were being utilized at the time.
So in the event that there are statutes with respect to product liability lawsuits and how a claimant asserts allegations and establishes, elements to prove their case, et cetera. What if those statutes conflict with 128.053?
What if they
Well, it
conflict?
seems as though your position is that any current defendant right now is entitled to a dismissal because no expert report was served.
Right, because and I've seen my time's almost up, so let me try to just respond to your
And
question.
please
Your
go
Honor.
ahead and we can make sure that we can give both sides the same amount of time. So
Sure.
this is an important case as it's likely one of first impressions. So
The way this statute is constructed, and it says it right there in it, is that the timing dates off of the filing of the original complaint. In this case, plaintiff chose to sue the shooting range and the manufacturers of the products owned and being utilized at the shooting range as part of their business. In so doing, based upon the plain terms of this statute, 128.053A's requirement, threshold reporting requirement, was needed to be met. Plaintiff never complied with that. He should not gain the benefit of not complying with that, and then you can unring the bell. There's nowhere in here where it says that this only applies for so long as ex-defendants are involved in this lawsuit. And there's myriad ways that the legislature could have limited this statute. And we point out in our papers that there's other statutes, a very similar threshold statute, the Healthcare Liability Act, section 74.351, which specifically defined defendant, specifically defined claim, and did not use the word suit, used the word claim. They purposefully narrowed it to only claims against the healthcare liability entities in that case. Here, the legislature made a different choice and broadly worded this and broadly worded the statute. And so when a plaintiff makes the decision to sue a sports shooting range and bring intermingled causes of actions and claims against the manufacturers of the products that were being utilized as part and parcel of their business operation, we submit that 128.053A applies, and plaintiff was obligated to, within the time frame specified within the statute, submit an expert report, Your Honor.
okay, and the statute doesn't speak to waiver. For instance, if a party such as Federal or Barrett waited almost a year to raise this, the statute doesn't speak to waiver, correct?
If I may, Your Honor, I don't want to, I know we're over time here.
It's okay.
No, there's no specific waiver language on there. However, the statute does have different places where plaintiff can talk to the other side and get an extension of time. In terms of waiver, I know plaintiff raised that argument in the trial court. That was not raised on appeal here now. But secondly, in terms of federal was amended into this case, and federal answered their complaint, and within their answer raised this specific statute as an affirmative defense. We moved timely within however long after that. We waited over 90 days after we answered out of abundance of caution and moved. So even if waiver were consideration or within this statute, there's no waiver argument to be had in this case, Your Honor.
Thank you, Mr. Lawless. Justice Watkins, do you have?
I do, counsel. Before you sit down, and I'll have the same question for the other lawyers who come to present oral argument. What should the content of this expert report have been as to your client? Should it have been, as the statute plainly says, the standard of care applicable to a sports shooting range, or should it have been standard of care applicable to an ammunition manufacturer?
Thank you for your question, Your Honor. And again, not to belabor the point, but just going back to the plain text of it, there's 2 points on that. One, there is no report here, so there's nothing for us to parse through. Second, going back to the plain text of 128.053A, it requires in a suit against a sports shooting range for an expert report to be served for each defendant against whom a claim is asserted.
If we stop right there, Mr. Lawless, if we think about that, when you're saying interpret this broadly or read this broadly, if we go back to the beginning of that section, in a suit against a sport shooting range, an owner or operator of a sport shooting range, or the owner of real property on which a sport shooting range is operated, there's no mention there of firearms manufacturer or an ammunition manufacturer as the legislature used in the title. So it seems to me that any defendant could have been brought in or sued, and that would apply, and that would not, in other words, you're suggesting that any defendant sued in this case could have had the protection of a dismissal because an expert report wasn't served on every party.
Thank you, Your Honor. And what I'm saying, what our position is that given the pleadings of this case, given the allegations, the shooting range, the standards applicable to a shooting range are directly relevant to the issues in this case, relevant to not only the shooting range, but Barrett and federal. The allegations include the fact that the business of the shooting range, rented and provided this ammunition as part of their business, clearly implicating the shooting range and clearly implicating federal and Barrett. It's our position that these defendants are intertwined. And so therefore, when plaintiff makes the strategic decision to sue all of them, section 128.053A applies, and per its terms, each defendant against whom a claim is asserted should get an expert report served on them. And that was not done here, Your Honor.
Okay, thank you, counsel.
Thank you.
Thank you.
Please, the court. Justice Watkins stated in a case just a couple months ago, it is the legislator's prerogative to enact statute. It is the judiciary's responsibility to interpret those statutes according to the language the legislature used. The appellants and the appellees in this case differ on how the judiciary should read this statute. The appellants would have you interpret 128.053 in a vacuum. The appellee believes it should be read in its entirety. You can't simply ignore part of a statute because it makes it easy for your client. Chapter 28, 128 has definitions that y'all talked about earlier at 0.051, the definition of the expert report and the definition of the expert. They talk about the report and the expert being with regard to the applicants to a shooting range. Appellant also believes that appellant's reliance on Shinogle is also misplaced. In Shinogle, the Supreme Court specifically held, you can't ignore any part of the statute or construe any part that would make it surplusage. You endeavor to read the entire statutes contextually to give effect to every word, clause, and sentence within the statute. It's important to look at what the Supreme Court did in Shinogle. If appellants are correct, Your Honors, and any defendant, because they were sued with bullet hole, was required to be given an expert report, Shinogle would have been 2 lines. You're a defendant, you get a report. Clearly, that is not how the Texas Supreme Court sees Chapter 128. The Supreme Court, to the contrary, went through to decide if they were an implicated defendant. In that case, Shinogle was the Alpine Range Safety Officer. The plaintiff handed the weapon to Shinogle, and while Shinogle was cleaning it, it discharged. The allegations in that, and you look at the plaintiff's allegations, were failure to use reasonable care in handling the firearm. They didn't argue in Shinogle about a negligent design, a defective design, or that the defective design itself was the producing cause. The standard of care in that case was the operation of the sporting shooting range. It was relevant to Shinogle's actions and the manner in which he handled the weapon. And because of that, he became an implicated defendant. Shinogle, the Supreme Court also said the right to dismissal with prejudice is not a question. We're not questioning that. Bullet hole, the range was already dismissed. That hasn't been challenged. The applicable standards of care, they were entitled to report. Here, the only question is whether the 2 appellees and the manufacturer appellants and the manufacturers can claim that same thing. As you identified earlier on the expert report, only three people are implicated in Chapter 128. The sports shooting range itself, the owner of the sports shooting range, or the owner of property on which the sport shooting range sits. Although the appellants would have this court recouch their claim to require a report, shoulda, woulda, coulda is not at issue here. It's the pleadings that are at issue when it is filed.
But counsel, let me just jump in. I'm looking at the plain text of the statute, and 128.053A says sports shooting range, owner or operator of a sports shooting range, owner of real property on which a sports shooting range is operated. It also uses the term each party, each defendant against whom a claim is asserted, and a defendant whose conduct is implicated in a report. B gives us even more, and it talks about a regular old defendant and an affected defendant. Doesn't your interpretation read all of those different classes of defendants to be implicated defendants? And don't we have to assume that the legislature chose different words for different reasons?
Your Honor, I don't believe so. I believe that if they had served a report on bullet hole, the other defendants should have been served, because you serve every defendant, and you can't just, but you still have to have some kind of standard of care. And I mean, I hop to what you said at the very end. You said, what would the report have said? That's where the problem lies. The report, according to the expert report, is the standards of operation of a sport shooting range. In this case, that does not affect either of the appellants. It wouldn't address their actions and the causal relationship between the injury and their actions.
How do you respond to their proposition that it is connected through the maintenance of the ammunition and of the firearms? Their proposition is that in the plaintiff's petition, under, I think it's number 25, causes of action as to bullet hole, number 25, B and H, they identify negligent maintenance of the equipment, meaning the firearm, and negligent maintenance of the ammunition. How do you respond to that?
Well, all of those are read with regard to the manufacturing process, Judge. And it specifically says the safety policies during the manufacturing process. So it's the failure to maintain them during the, when did the defect happen? Presumably at the plant, but where along the way, I don't think they know yet. This case is still pretty much in its infancy in a lot of ways, but the you cannot read a statute if somebody's going to raise such and such defense. The plaintiff here did not allege that the way it was maintained at Bullet Hole is what caused the action, the injury. They didn't say anything along those lines. They didn't say that the way they packaged it upside down on its side up to the left is what caused the injury. To the contrary, they said the design itself of the firearm and ammunition is what caused the injury. There is a very specific statute on that. Chapter 82 talks about products liability. We are taught over and over that you go to the more specific statute. In that one, you have the design and the defect is an issue. But back to Dr. and Justice Watkins' question, the report in this case would have nothing to do with the injury alleged. In fact, if you follow the plaintiff's pleadings, where it happened is completely irrelevant. Chapter 128, I think it's important. The Fort Worth court went through and analyzed the purpose of 128. And they said it was to protect safe gun ranges from legal harassment, to add a legislative hurdle to frivolous lawsuits, and to accommodate Texas liberalization of gun laws. It wasn't to protect manufacturers from ordinary care of a firearm in creating it. That's not why Chapter 128 came about. They want the ranges done properly. If people are going to go, it's an inherently dangerous thing. They want to make sure that they are being run properly. That's exactly what they talked about in Chernobyl. That is exactly what they said when they talked about, he was the one that held it. He was the one that used it. He was the one that it was in his hands when it went off. That is why he was an implicated defendant. There would be no reason for the court to have gone through the analysis they went through if simply every defendant got a report because it happened at a firing range. The reality is in this case, it was a defective design. It does not matter whether Mr. Flores was standing at the firing range in North Star Mall or in the middle of Fiesta, Texas. It exploded. Where he was didn't matter. Chernobyl also, the Supreme Court in Chernobyl also.
Ms. Rosenblatt, though, here it does matter because 128 kicks in because of where Mr. Flores was at the time of this accident. So I'm not following what you're saying about it doesn't matter where he was at the time.
So also part of the analysis that the Supreme Court did in Chernobyl was it compared it to what it thought was the closest statute, and that's the healthcare liability claim. And it went through a bunch of different cases, and there's a bunch more cases where the courts have done the same thing. And it didn't matter if the injury happened at the hospital. What mattered was whether it was a medical healthcare claim. So they looked at, there's a Nexian case, which was a slip and fall in the hallway. KSAS versus Williams, the front door of the hospital malfunctioned. Ross versus St. Louis was a Supreme Court case, St. Luke's Hospital, I'm sorry, where it was once again a slip and fall. In each of these cases, the court held that the injury was not a healthcare liability claim. Just because it happened at a hospital did not convert the premises liability to a healthcare liability. There's no difference here. But even more, there's a case, Verticor versus Wood, also a Texas Supreme Court case in 2015. And in that case, they looked at even more specifically what I think is related to this case. It was a design defect in a hospital medical device that the hospital was using. And in that case, they sued for products liability on the design of the medical equipment. The court held that the motion to dismiss was improper because the manufacturing of the medical device was not healthcare. That is the exact same thing here. The manufacturing and the poor design in the manufacturing process has nothing to do with the shooting range itself.
Okay, the allegation in the second amended petition states negligently and carelessly failing to provide safe equipment, failing to properly maintain its equipment, and then H, echoing what Justice Rodriguez mentioned earlier, negligently and carelessly maintaining its ammunition. So in the event, the argument is the products themselves were altered in some way. How does that play a role into your position? And if not,
I apologize. I'm not sure that I follow you. Altered in some way where?
Altered in some way that when it left the manufacturer, for instance, If there's an argument that Bullet Hole failed to maintain the equipment as to what the manufacturer's policies are or instructions, et cetera, isn't there an argument that the products themselves could potentially be in a different state as to when it left or they left the plant?
But that would be a case against Bullet Hole. And they raised that as well. If Bullet Hole did not handle the product properly, and because of the way they handled it, that would be the operation of the shooting range. That would be Bullet Hole. Barrett and Federal were never on the firing range. They weren't there. So if that wasn't handled properly once it got to the firing range, that was the case that already got dismissed.
Okay, but we're still, I mean, even though Bullet Hole is no longer a party, we still have to contend with Chapter 128, do we not? It's based on the procedural posture of this case in terms of it being a permissive appeal.
Oh, I don't disagree, but I guess the question is whether they deserved it at the time. And so in front of the trial court were all three parties, right? So there was Bullet Hole, there was Barrett, and there was Federal. The trial court dismissed against Bullet Hole. And so any allegation that it was not handled properly or not handled not stored properly, not whatever, that it was damaged at the firing range, that was against Bullet Hole itself. And those have already gone away. You can't recouch the plaintiff's allegations by some defense that could maybe evolve in the future to hold that the range is the standard of operation at a range. There's nothing about the allegations against Barrett and Federal that have to do with the way it was the range itself was operated. If you got a report, I don't know how it would say anything about the design defect. The design of the range, the operation of the range, the way they set it up and all of the different parameters that they go through has nothing to do with the defective design of the firearm or the ammunition. And the causes of action that they had were defective design against the ammunition and the firearm. And so I think that that's the problem, that you can't have your cake and eat it too. You can't read 1.053 in a vacuum and say any and all defendants, and then rely on Shinogle, where the Supreme Court specifically goes through the analysis to see if they're an implicated defendant. It's not just any defendant. It has to be an implicated defendant with regard to that statute.
So do you concede that they should have received a copy of the report? And then we move on to the second part of that analysis, which then we must determine whether they're considered an implicated defendant?
I don't believe so, because there's nothing in there that the report would address. It's one of the questions that Shinogle, that they looked at in some of the other cases, was what would that report say? And in this case, what would that report say? Let's take the example that you had earlier with regard to the doctor. So his surgery gets messed up on his hand, right? So we've got a med mal case against the doctor, but they bring it in all together, judicial economy, all the facts line up. You go from here to the ER, from the ER to the doctor. So they bring it all together, right? You can't say that anything that happened in the firing range would have changed or affected the way the doctor cut and sutured in the operating room. It's the same case here. If they gave you a report, an expert report on the standards of care, the way it should have been handled, it wouldn't be applicable. The implicated defendant in that case would not be the doctor. He might be a defendant in the case, but not implicated under Chapter 128.
So what you're saying is the statute provides the doctor would have been entitled to a copy of the expert report addressing the shooting range's conduct or misconduct.
If there was a report, absolutely. But I don't think that's any different than any other discovery that you get or any other report or anything else. That he's not an implicated defendant with the need to have a report written.
Okay, so then it's not your position that every defendant in this case was entitled to a copy of an expert report.
Oh, I do believe they were, but I think that that's true in any case. I'm sorry if I misspoke. I think that's true in any case. They're not entitled to an expert report about each defendant, but if there is an expert report implicated under Chapter 128, in this case against Bullet Hole, and they had prepared one against bullet hole and they didn't get a copy, which it's a lot of steps along the way, I think there would be a real gripe, right? But that would be hiding behind stuff, and that'd be a whole discovery kind of a thing. But the report in this case would be making attorneys jump through hoops for zero reason, for something that would have no bearing. It would not come in at trial because it would be irrelevant. You would never get that report or officer to testify because it would have nothing to do with the cause of the injury. You have to show a causal relationship. That expert would never be able to type, unless he had a completely different expert report about why it was manufactured improperly, the design and defect. So you wouldn't even be able to get his report or his testimony in because it would be completely irrelevant.
Ms. Rosenblatt, let's go to 128.053B. How do you interpret B in terms of the language used as affected defendant? What is an affected defendant in with respect to 128?
I think it's similar to the implicated defendant. I think it's, is this an affected defendant under the statute? Is this defendant somebody who is entitled to the report?
But why would the legislature have chosen different words to mean the same thing? I mean, the problem that I have, one of the things that is just, I find very difficult to parse about this statute is all of the different words that kind of, in our legal parlance, mean the same thing, but under our statutory rules of construction, we have to assume the legislature meant different things with them. Help me out there.
So I think that I used to talk about when I had juries that you don't check your common sense at the door, right? If you type in 128.053, 128.051, there's like 5 or 6 cases total that come up. Total. 2 of them belong to Barrett. I'm sorry, 2 of them belong to Shinogle. I don't think it was meant to be complicated. I mean, they pretty specifically said, and I don't think the legislature is ever the best for words, but they pretty specifically designed it to be about the range. And in this case, the case against the manufacturer and the fact that it was designed wrong has nothing to do with the range. There are cases in Ray Wade, which was out of the Fort Worth court. And in Ray Wade, the neighbors argued that they put up these areas to protect the shooting range. They put up these big boxes, metal boxes, and what ended up happening was it diverted the water. So the water goes from the firing range now to these neighbors' houses. So they sued. And so in that case, it was a case against a gun range. The difference was in that case was they also argued that they were afraid of live bullets coming onto their property, and they were afraid of the noise, that the noise was causing a nuisance. So the court said they didn't need to discuss the use of the land as a shooting range. The opinions concerning the standard of care, design, and drainage so that water would not properly divert was not the basis of the 128 expert report. They were 2 completely different issues. So if you were going to look at them with regard to what happened with the complaints of the noise and complaints of the spare bullets, and you can see that that's where the whole statute came from, right? People are hearing pops and noises, probably ducking under beds. And that's the reason that the whole chapter 128 came about. But 128, the standards of operating a shooting range, in that case, wouldn't address the diverted water. So he didn't have to address the diverted water because it wouldn't make any sense for this expert to address that. It's the same thing here. It wouldn't address what part of the design made this thing explode. And I go back to that location thing. This firearm exploded. It didn't matter where they were standing. The firearm exploded in his hand. He didn't say I was shooting it and something was in the way. He didn't say I had to divert quickly and that's what caused it to jam. Nothing like that. It was not the way an ordinary customary person would expect this device to proceed. And I think that that's really important here because I really do think that it goes back to what you asked. What would the report say? And I think that that's exactly what they looked at in Wade. I think it's probably part of this analysis that the court looked at in Shinogle. The report would talk about how they were supposed to take a gun when you came in, how they're supposed to clear it, how they're supposed to do all those things. It was while he was clearing it in Shinogle that it went off. That is the operation of a firing range. And that's why that action itself is what implicated him as a defendant and why they needed a report. If it was any defendant, why would they have gone through all of the analysis that they went through? It seriously would have been a 2-line opinion. He was a defendant. Statute says any defendant. He deserved a report. And clearly that's not what they did. As we talked about before, they enacted the statute. It's your job to interpret it. Neither defendant in this case, it's undisputed. They're not a sports shooting range. They're not the owner of a sports shooting range. They're not the owner of property at sports shooting range. Bullet hole was dismissed because they were. Chapter 128 specifically applied to bullet hole. The trial court got it right. This is a question of an exploding firearm. The design itself was defective. It was the design that caused the injury, not where he was located. It was not how the shooting range operated. They gave him six pieces of ammo or 42 pieces of ammo, if they gave it to him hot or cold, none of that was even relevant or in the pleadings. The pleadings are very specific. Products liability. There is a very specific statute, chapter 82, that talks about products liability. The business here was the firearm and the ammo, how they built it, how they designed it at the factory. Once it got to this, and you can look at the pleadings, and granted, I think we can all come up with great, crazy, different examples of when something might happen at a firing range that would then implicate the manufacturer. But that's not what we have here. They're pretty straightforward facts. And this court is bound by the pleadings themselves. And there's no pleading anywhere that says that it was how they maintained it at the firearm. It was how they maintained it at the manufacturing that they alleged. It was how the safety policies at the manufacturing process that were alleged. They designed it improperly. They built it improperly. They etched it improperly, whatever it was that caused it to explode. I don't think they've actually gotten that far.
So you're saying that the way the shooting range maintained the ammunition or the rifle had nothing to do with the cause of action, that there's no connection there?
Not to the cause of action against Barrett and Federal, totally did against the firing range, but theirs is for a design defect. So what the firing range did with it doesn't affect the design defect at all. There's nothing further.
Thank you, Ms.
Thank
Rosenblatt.
you.
May it please the court, Jamie Parker. What a fascinating little case, isn't it?
It's not so little.
Well, but in terms of amount of briefing, I mean, I think the briefs are 20 pages long or less or something like that. So it's a nice little case for everybody to sink their teeth into. A couple of things. Justice Watkins, you said, what would have been in the expert report? Their very first cause of action as to bullet hole, negligently and carelessly failing to provide safe equipment. Okay. They keep talking about defect. It's a defect allegation. What's the basis of a product liability claim? It's the placement of a unsafe product into the stream of commerce. So they make an allegation against bullet hole, upon which an expert report is going to have to be provided if they comply with the statute.
And what paragraph of the petition specifically are you looking at?
It's in paragraph 25A.
Okay.
Negligently and carelessly failing to provide safe equipment. So their expert report, had it been filed, would have had to have said something about why this equipment was unsafe. And why that's important is because that's what they're saying against us. It doesn't, I mean, they can say it, well, it's a defect or it's this or it's that. But what they're saying against Barrett and against Federal is that the product that you presented or that you gave to or sold to the firing range It was an unsafe product.
But isn't that fundamentally different than the liability that started in the manufacturing process years ago and way upstream?
Well, I mean, yes and no, because the whole idea of if it's a safe piece of equipment or not, the expert report would have had to provide something about that. And that expert report, it's a hypothetical expert report, of course, but it would have had to have said, okay, it's either there's a defect in the product or there's a defect in how the product was maintained. Because
Did any of the defendants file any special exceptions or anything to complain about the lack of specificity in these
I don't-
allegations?
it's not up to us. We don't have to, I mean, that's not our burden. I mean, to me, at least, it's pretty clear. And that goes back to the
What
whole,
is your burden though, Mr. Parker, is that you have to convince us that you're an implicated defendant and an affected defendant
right, well,
for purposes of this appeal. So, and assume that we're not convinced yet.
I never got that impression. Your Honor.
Okay.
The bottom line is that, look, the legislature has basically three different statutes that all kind of deal the same way, right? You've got this one, you've got chapter 74 for the medical thing, and you've got chapter 150 for the architects and engineers. The legislature very clearly under either 74 or 150 knew exactly how to say, we're limiting this to healthcare or to architects and engineers, had they chose to use the language, because it's very clear in those as to how the legislature handled it. They didn't handle it that way here. They made it much more broad. They used the word defendants. They used, and so there's no ambiguity in the language that the legislature used here. None
Mr.
whatsoever.
Parker, arguably though, the way the 128.053A starts off is they do limit, I mean, that's what I'm saying, arguably, they do limit to the sport shooting range owner or operator or the owner of the property itself.
And then if you read a little bit further down, it says defendants. It doesn't say like it does, for
Right.
example, in
But why can't reasonably or argue, maybe not reasonably to you, but arguably those defendants perhaps are limited to those already mentioned.
But that's what I'm saying, Your Honors. If you go back and you look at the way 74 and 150 are done, that's the legislature could have done that here and they didn't. And that goes back to their argument about the slip and falls at hospitals, right?
Does that go outside of what we should be doing here in terms of our review?
No, it's because it's all statutory review, Your Honor. In other words,
Okay.
there's not they're not claiming ambiguity. We're not claiming ambiguity. So it's what do these words mean? The words that the legislature used. And no one's claiming that this is one of those absurd results. Okay. In other words, there's always the case law that says, even if you could read it, you can't read a statute that says that come to some absurd result. We're not there with this fact pattern. In other words, if there was a car accident in the parking lot of the range, you wouldn't say that this statute applied to that because it has nothing to do with the operation of the range. Just like the cases that they brought up, which were the slip and fall cases. And you'll all remember when chapter 74 was announced, the first kind of thing that came out was all of the hospitals saying, well, the slip and fall is a healthcare liability claim too. And some courts said, yeah, you're right. But most courts, the majority said, no, that doesn't apply because you know why? There's no nexus between the slip and fall and the health care that was provided at the hospital.
But then in Potts, the Supreme Court said, if you have a valid expert report as to one theory of liability, then the whole case gets to go forward. And it seems to me that by analogy, your argument is the exact opposite of that none of the claims should go forward, even the claims that clearly are not against a sport shooting range.
Well, but the point that those cases all made was the nexus between the claims of the against the hospital. And here it's the nexus of what's being alleged, the nexus of how they chose to bring their case.
So what would you have done differently other than, not being able to what litigation tactics would you have taken differently if you had gotten an expert report that talked about either Barrett's liability or the standard of care that's applicable to a sports shooting range?
We would have gotten an expert report that told us why the equipment was unsafe. Because that was one of the arguments, that's one of the very things that they pled against Bullet Hole, was that the equipment was unsafe. Okay, we are now affected by that. There's a nexus between the claims against us and the claims that they've made against Bullet Hole. And so by not providing safe equipment, we would then know, we would get an expert report that said, this is what was wrong. This is what was unsafe, defective, however you want to say it. This is what was unsafe about the equipment that was provided to me. We were entitled to that because of the way Schnagel, and I go back to Schnagel and the actual language that the court used there. The court specifically said the statute is not limited to the shooting range owner or operator, but also applied to a defendant who is not the range operator itself. And the court said the legislature chose the word defendant in its definition of expert report and did not expressly limit the expert report contents to addressing only the actions of the shooting range itself.
But then that argument bumps up right against the definition of an expert report, which only requires a fair opinion of the standards of care applicable to a sports shooting range.
But it would still, based upon their pleadings, they were going to have to provide some expert report about how the equipment was unsafe. That's
Okay, but
that's the
they're-
nexus.
But with respect to Bullet Hole, however, they are asserting that the gun or the rifle or the ammunition rather is unsafe based on its faulty maintenance. So that's separate and apart from its design.
I don't disagree with you, Your Honor, but they would have had to have an expert report that said why they failed to maintain it, why they failed to inspect it, why they failed to properly train their staff, how all of those
Okay,
things.
but
did.
how does that implicate Barrett or federal?
Because they're saying that the equipment itself was unsafe. And that's the claim against us.
Okay, but based on how it was maintained.
No. Negligent, they're separate allegations, Your Honor. A is failing to provide safe
Are
equipment.
you on page 4?
I'm on page 4, Your Honor, 25A. Then you go down the list. There's a separate one for maintain. There's a separate one for inspect. There's a separate one for failure to train. All of those, we would have been entitled to an expert report under sub A because that is directly, there's a nexus directly between that and the claims against us, even if they're denominated as something other than negligence. So the last thing to talk about in Schnagel is what at 778, where the court said to read the statute the way the Whitlock suggests would render the word defendant meaningless or mere surpluses. This we will not do. And it's the same thing. That's what's happening here. The legislature chose the word defendants or defendant in describing in the original part of the statute as to who was entitled to get those. And we're a defendant.
But I'm looking at page 7 of the petition where the causes of action against your client Barrett are laid out. And it reads to me like every single one of those specific allegations happened at some point in time before Mr. Flores stepped foot on Bullet Hole's property.
That may be true, but it doesn't matter because the report that was due would, excuse me, my time's up, Your Honor,
Go ahead, sir.
would involves the provision of safe equipment. So we would have been entitled to know what was unsafe about our equipment. And I mean, it's not ambiguous. It's not an absurd result to interpret it the way that the language reads. And so therefore you don't go to what the legislature intended or all those other things that they brought up because none of that's relevant. It's simply what does the language say?
But you would agree with me that if Bullet Hole was never named as a defendant, you would not have the ability, your client would not have the ability to assert this defense.
Oh, you're absolutely, Your Honor. I mean, I think 120 only comes in when there is a suit against a shooting range, which there was here. And once there's a claim against the shooting range, then and just the way the statute reads, the defendants are entitled to the report.
Mr. Parker, you said that your client is entitled to know why this equipment was unsafe. Aren't there other remedies and statutes with respect to manufacturers that go to the crux of your argument?
Well, I mean, certainly at the end of during discovery, you're going to be able to find all those things. But we're only talking about here about whether or not we're entitled to be dismissed because they didn't provide us the expert report to begin with. It's the same as if we were architect engineer, the same if we were healthcare people. As long as there was a nexus between the claims, which I think there is here.
Right, but let's assume that they did produce a report and they provided you with a copy. What if they never mentioned Barrett or federal in that report? What then?
We'd have to deal with it that way at that time, Your Honor, because we don't know. We don't know what was going to be in the report. We know what should have been in the report, but it just was never given. So I don't know how to answer that because it depends on what's in the report.
It's hard to establish yourself as an implicated defendant or an affected defendant without the report.
You can. I think I've re-raised that in our brief is that we never get to the issue of the sufficiency of the report because one was never provided. And so, and a lot of the language that we've been talking about is post providing the report in the statute. And so I don't know that we ever even get to that point, but I mean.
But then how do you respond to Ms. Rosenblatt's argument that Shinogle should have been a short 2-sentence opinion?
It was pretty
He was a
short.
defendant. He's not entitled. He didn't get a report. Dismiss.
Well, I think because the way the court went through the argument, I mean, the court went down every argument that the plaintiffs made there, which is exactly the arguments they made here. The employee's not in the statute. And just like the manufacturers are not in the statute. And the court said that reads defendant too narrowly. That if the legislature had wanted to say something different, it would have chosen a word different from defendants because we all know what defendants mean. We don't have to have that defined by anybody. And so that's why why we believe that Shinogle's favors us, which makes it really kind of funny because both sides here are saying Shinogle's in their favor. And so that's why I say this is such a nice little case because it is it's fun. Maybe not so much fun for y'all, but generally speaking, I mean, you don't get a case like this where the issues are so like you said, a question of first impression, perhaps. Although it's kind of a second impression because it's Shinogle, but just a little bit different. And that's the key too, and I apologize, I'll step back. But the Shinogle, you had the plaintiff provided his own rifle and own gun. And so there's a factual issue that's different there, but the way that the court treated the term defendant in deciding whether or not not immunity, but the expert report applied, that's to me what's the key because
Right, but their fact scenario, which we don't have here, is that the employee, and I'm not focused on, the statute doesn't specifically state employee, but the shooting range and the employee are one and the same as a matter of law. So, and here we don't have that. So, I mean, it seems a little bit easier to implicate an employee of a shooting range when you have that legal theory to support that, that rationale. Here we don't have that.
I don't necessarily disagree with you, Your Honor, but what I would say is that the court made very clear that the term defendant was broader than what the three specific ones that were laid out in the statute. In other words, that was exactly the argument the plaintiffs made in the other case. And the exact argument that they're making here, in essence, is you're not part of this. You shouldn't be a part of this statute. Supreme Court said, yeah, they are. So I don't relish your job. So, but anyway, unless there's anything else, we'll leave it on the briefs.
Thank you, Mr. Parker.
Thank y'all.
Counsel, thank you for your excellent arguments today. It was great to see you, and your case has been submitted, and we will issue the opinion as soon as possible. Thank you.
All rise.